Hello and welcome to today's program titled Italy, Spain, and France, Current Trends and Upcoming Regulations in the European Employment Law Landscape. All participants are in listen-only mode. However, you're encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, the code will be read later in the presentation. Please write this code down as it will not be repeated and it's required for CLE credit request form. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker. Lawrence, you may begin.
Thank you, Sophia. Good morning, good afternoon. Welcome, everyone. Thank you for joining. We're going to spend about 45 minutes. We're talking about employment law developments in Italy, France, and Spain. We're going to jump in Milan with Sophia. Next slide, please. Next slide, please. Sophia is going to talk to us about parental leave and health and safety developments. We will then head on to Spain. Anna will talk about remote work and work-life balance issues. I will talk about pay transparency and unfair dismissal damages from a France perspective. So I will hand over now to Sophia.
Yes. Hello everyone. Buongiorno, buonasera a tutti in Italian. I'm starting speaking about paternity leave and parental leave in general. What's new here? This is not a hot topic, so a very new reform in Italy. I want to touch on this because this is something that we have been in Italy amending for several times in the last 3-5 years. So I think it's important to speak about the paternity leave entitlements and parental leave in general, because this is something that was not amended in 2024, but we had several different small amendments in the last 5 years. And I think that in particular before the summertime, it's important to know that these entitlements exist. So why we start from a paternity leave? We start from paternity leave because at the very beginning, only mothers had leave entitlements to take care of the newborn. Now, also fathers are entitled to 10 working days paternity leave. So fathers can enjoy those 10 days that are fully paid, so 100% of the salary is due for those 10 days. They can enjoy those 10 days in the 2 months before, and in the 3 months after the date of birth of the child. Why this is new? This is new because, as I said at the beginning, fathers didn't have any entitlement to stay off for the birth of the child. Then Italian law, the Italian Parliament introduced 3 days of paternity leave entitlement, and those 3 days had to be taken immediately after the birth of the child. Now the 10 days can be enjoyed all together when there's the delivery of the baby, or they can be taken, as I said, in the 2 months before or in the 3 months after the birth of the child. Why the 2 months before, the 3 months after? Because this is the normal period for maternity leave. So it's a sort of additional support to mothers from fathers. Now there's an ongoing discussion whether the Italian Parliament, the Italian government, the parties want to extend the paternity leave to equalize it to the maternity leave. So if the paternity leave will be raised from 10 working days to 5 months, like maternity leave. This is still far. So it's only a discussion, it's a suggestion. This is something that we are there are rumors speaking about this, but it's not actually under discussion. In general terms, fathers are not only entitled to the 10 mandatory days of paternity leave, but they can take, as mothers, so parents in general, they can take 6 months parental leave. That can, by the way, be taken before the children are 12 years old. This is really important to know, because the parental leave is an additional period, additional to maternity leave 5 months, additional to paternity leave 10 days, that can be taken by both parents alternatively, so the mother or the father, but before the children are 12 years old. Those days of leave can be taken all together, so 6 continuous months, or in weeks, or in days, giving the employer a minimum of 5 days notice, or even on an hourly basis, giving the employer a minimum of 2 days notice. The introduction of the possibility to enjoy those leave, these days of leave, also on hourly basis, was really disruptive at the beginning. It's not so common to use parental leave days on an hourly basis, so divided into hours. But it's, by the way, a possibility for parents. Parental leave days are paid at 80% for 1 month and 30% for the rest of the period by the Italian Social Security Authority. By the way, the salary is always anticipated by the employer, so the employer will pay and then will recover from the Italian Social Security Authority in the upcoming months, so deducting from amounts due to the Italian Social Security Authority. Sometimes the employer is obliged to top up a little bit the salary during those periods of leave, depending on the national collective labor agreement requirements. Possibly also this can be agreed with the unions at the companies level. Why I was mentioning the fact that we have to discuss this topic before the summertime, because parental leave days can't be denied. So whether if the company can, the employer can refuse or deny the holidays if working reason exists, but this is not possible for parental leave that are must be mandatory, approved by the employer. So sometimes during the summertime here in Italy, we have this problem. So people that can't go on holiday apply for parental leave, given that they can do that until the children are 12 years old, so for a long period of time. I know that in Spain, there's something a little bit different, so I would ask my friend Anna to jump in.
Thank you, Sophia. So yes, there has been the paternity leave has been on the agenda for many years, and it kind of moved from the historic 2 days of leave, then it was increased to 15 days, then it was increased to 2 months, until the current situation where we're not talking about paternity leave anymore. It's called the birth leave, so it's given as a result of the birth of the child, and it is 16 weeks for both the biological mother and for the other parent. So these 16 weeks can be taken, the first 6 weeks are mandatory for both the biological mother and for the other parent. The difference is that the biological mother can also anticipate 4 weeks before the birth, and then they would have the remainder 10 weeks can be taken anytime after the birth until the child reaches the age of 12 months. So there's kind of more flexibility, and there's an equal treatment for both parents in order to take the birth leave. Also, in case of adoption, the same permits would apply. There's a bit, that different drafting, but in the end, it's again 16 weeks. 6 first weeks are mandatory for both parents. And in case of an international adoption, it also provides the 4 weeks prior if the parents need to travel. And they would start not from birth, obviously, but from the date when there's the adoption resolution is implemented. So we are in a situation in Spain where basically both parents will have the same rights after the birth of the child.
Thank you, Anna. So slightly different from here. Next slide, please. So the second and third topic I want to touch here are a very new reform on contract staff leasing and health and safety. This is actually really new because this was implemented in March 2024 and confirmed by the Parliament in May 2024, so a month ago. These are two small amendments to the current legislation that, by the way, have some implications, and I want you to be aware of these new rules. So the first one is that unlawful contract and unlawful staff leasing are again, as they were before 2016, potentially in some specific cases, of course, not always, but a criminal offense, leading to criminal fines up to 50,000 euros and imprisonment up to 3 months. Honestly, there's not a big difference on the fines applied, because the fines also before this very new reform was capped to 50,000 euros. But the problem is that the introduction of the violation as a criminal offense leads to a potential criminal exposure of the legal representative of the company, as well to possible impact on the company's eligibility to participate in public tenders. So why this is important? From the economic perspective, is the same as before, because the fine is capped. But the fact that now in some extraordinary specific cases this can be a criminal offense may lead to additional responsibility. So it's important to know. The second matter topic that was touched by this new reform was the fact that companies as well as individual contractors working on construction sites. So this is not applicable to everyone now, as of now, but only to companies working on construction sites are obliged to declare to the Ministry of Labour that they are in line with the main health and safety requirement. This is a self-declaration that must be issued by companies working in construction sites, and this provides company and contractors making this declaration with 30 health and safety credits that will be lowered in case of health and safety violation ascertained by courts. Companies with less than 15 credits cannot work on construction sites. I know that this is really a technical point, but in my experience, I saw many foreign companies, in particular US companies, posting employees to Italy, technicians to come here to work, to help clients, customers, or also other Italian branches, with technicians posted to Italy to work in construction sites. So it's really important that you know that there are additional requirements on health and safety. Health and safety is a hot topic now. We had in Italy so many fatalities since the beginning of the year that this is under the attention of all the labor and health and safety inspectors. So this is an important topic, health and safety now in Italy. Next slide, please. And I think we're going to Spain. So Anna, Sid, can you please take the lead now?
Thank you, Sophia. So the topics we're going to discuss today with regard to Spain are both the ones that I find are interesting for international companies doing business in Spain, and especially in this environment. I'm starting with the first one is remote work. Obviously, this is relevant to any country at this time, but I find that many times regulations are not really well known by, and this might be because of the environment where we are now, where there's some companies would provide some flexibility to employees and they can decide to work in the office or in the company premises, or they can work from home or somewhere else, and they have the freedom to set up the days that they're going in or not. And also the hybrid environment will also grant that flexibility. And I sometimes find that companies that are operating in Spain and that provide that flexibility are not fully aware of the obligation that was implemented by the Remote Work Act. So the Remote Work Act has been in place for a while, like from 2021, and obviously as a result of the pandemic, a lot of countries, including Spain, implemented this regulation. There were some small regulation in place, but it not as detailed as now, and it didn't include all the obligations that are covered here. The main thing to know about this regulation is, first, what is considered remote working, and that triggers these obligations. And that is defined under the law as the employees that work remotely in a place outside of the company premises. So this doesn't necessarily have to be their home. It can be somewhere else, but it's outside of the company premises for at least 30% of their time on a 3-month period. So, when we're talking about the flexibility of you come in some days, or, the employee has a right to decide, then if we take a 3-month period and we look at how many days the employee has been in the company premises or not, then we will come up with a conclusion on whether the remote work agreement is applicable or not to this particular employee. So the limit is, as I said, the 30% in a week period, it would be 1.5 days. So for those companies that have this hybrid model, where the employee has the possibility to has the obligation sometimes to come into the office for 3 days and then work remotely 2 days, the remote work agreement would apply for those 2 days. The main obligation, and they're various, but I think the most relevant one that covers a lot of the small obligations that have to come in play are that there needs to be a remote work agreement. The remote work agreement has to be in writing, has to be negotiated with the employee, and it can be by means of a separate agreement that kind of just governs the issues that are relevant to the remote working, or it can be embedded into the employment agreement. So there are cases where the company would just have a contract, an employment contract, that would include not only the provisions that are mandatory in an employment contract in Spain, but also those provisions relating to the remote work agreement. As I said, the remote work agreement has some specific content that is listed by the law, and the main one that I would like to flag is, first, the equipment that is being provided to the employee. So what are the tools that the employee needs to work? List the ones that are being provided, and also the duration of the renovation period. So, this equipment should be replaced after 5 years, whatever many time. Then the costs that are going to be covered by the company. The employee doesn't have to bear the cost of working, so the company should reasonably negotiate with the employee what are the costs that are being incurred as a result of the work remotely, and they should cover that, and specifically mention in the agreement that is the amount that's being compensated as a result of that. That amount is going to be defined by the collective bargaining agreement. And a quick point here, mostly every company in Spain would be subject by a collective bargaining agreement. The collective agreement is kind of a rule that would apply to any relationship in Spain, and it is defined by sector of activity. Some companies would have their own collective agreement because they negotiate with the unions. Other companies would be just bound by the industry-wide collective agreement for the specific region. It can be by province, autonomous community, or a national level. But the collective agreement contains some minimum regulations, and now they tend to include also remote work provisions and the amount of expenses that need to be compensated. And then finally, the other relevant aspect that I would like to flag with this remote work agreement is that this needs to be communicated. It needs to be registered with a registry with the labor authority. So it is an agreement that is set up between the parties and then filed with the authority, like the basic terms of the employment contract that also needs to be filed. And a copy must be provided to the employee's representatives. The employee representatives will have to receive such copy. If the company doesn't have employee representatives, fine. But if not, then they would have to get this copy. And I'm calling employee representative because we have two different bodies. In Spain is the Works Council, and we also have the staff delegate. Depending on the size of a company, the number of employees, you would have one or the other, but the rights are basically the same. They're just employee representatives with the same abilities. And I understand there are also some remote work provisions in Italy. Sophia, would you like to flag some of it?
Yes, so rules are very similar to Spain, but in Italy we always need a remote work agreement, even if the employee is allowed to work remotely 1 day a month. So we always need that, and there are also health and safety obligations when it not honestly obligation in the sense that the employer has to do something, but there are health and safety information obligation. So we have to, the employer has to inform the employee on health and safety rules, additional health and safety rules in case of remote work. We in Italy, there's no provision obliging the employer to pay for the tools to be used at home, but it's normal practice, honestly, to provide employees with an indemnity to set up their home offices. And likewise in Spain, we the remote work can be done, so the employee can work wherever he wants. It doesn't need to be home, because for people working from home in Italy, we have a different agreement. So there's a teleworking agreement for people that are based at home and not simply going to the office some days and working from home or from everywhere else some other days. So, but it's very similar as to Spain. We have to register the remote work agreement with the Italian bodies, and so yes, similarities over here.
Yeah, and you actually mentioned a couple that are I didn't mention, but they're also applicable in Spain, which is, the place where the employee is working has to be set up in the remote work agreement, because the company is liable for health and safety. So even if they're not working in the office, there should be health and safety measures and prevention, and there will be different ways in which this can be implemented via self-assessment or different types of review. But the fact that the employee is not in the office doesn't mean they are not covered, and so obviously that would apply to. How about France? What is the position in France with the remote work agreements?
Thanks, Anna.
Regulations?
Yeah, in France, oddly, there is a labor code provision saying employers should put in place their teleworking, teletravail arrangements by means of a company level collective agreement or unilateral charter. In fact, not many employers have done that. If you have neither of those agreements, neither the agreement or the charter in place, the Labour Code says, well, you can agree individual remote work arrangements with employees without any particular formalities, and that's the most common approach. One recent thing worth mentioning, a so-called home occupation allowance. Now, this is quite separate from any obligation in France to reimburse expenses incurred due to remote working. There is a requirement to meet those expenses. It's quite commonly done by a fixed allowance, and up to certain limits, that allowance can be paid without attracting Social Security charges. But in addition, there is this occupation allowance. This applies according to French case law. It's not statutory. It's been invented by French courts. It applies if the employee has no choice but to work remotely. So you don't have to pay it if the employee could be coming into the office to work there if he or she wanted to. It's existed in principle under French case law since about 2010. but is quite widely ignored in my experience. It was confirmed in recent French Supreme Court decisions in November and December 2023. So it may be picked up more by employees' lawyers in future. There's no clear guidance on what the amount of the monthly allowance should be, but generally, if you look at court decisions, the idea is you take into account how much of the employee's flat is given over for work purposes, that kind of thing. Anyway, back to Anna for more on Spain.
Yeah, thank you, Lawrence. And that's interesting because I see that sometimes some of the questions I get is, well, the employee is actually requesting to work remotely. We don't have a presence in Spain. They just want to live there and work there. And that doesn't mean that the remote work provisions wouldn't apply and that the compensation of expenses are not triggered. So it's an important aspect to take into account. So moving on to the next topic. This is the result of the implementation of the Work-Life Balance Directive. It kind of created some new rights, others were already in place. So the main one that I would like to flag is that it kind of extended the circumstances to request accommodations to work time, including the duration of the work time, the distribution, and the performance of work. And why I'm flagging this, and this was already in place, like the directive, the implementation of the directive kind of just extended when it was applicable, but it brought to light a provision that was already there, which is, in terms of the performance of work, it also includes how the employee is working and the possibility to request working remotely to take care of a family member. So in order to allow the work-life balance rights, and I mentioned here that in case this is requested to take care of children, it has to be a minor up to 12 years old, but it provides the and it has to be reasonably and proportionate with the company business. But there is an obligation for the company to consider the accommodation request, and if refused, it has to be justified. So it doesn't. The company cannot just say, well, your contract is not remote working. You have to come into the office, or your working hours are this and you're working on shifts and this is your terms agreed. If there is a reasonable request and the grounds and justifications fall within the scope of this article in the law that provides for these accommodations, then the company can only deny it. It has a 15-day period to accept or deny, and it can only be refused by reasonable business grounds. So it cannot just say, these are not the terms we agreed. And I find that this is sometimes kind of ignored or not known by employers until they get the request from the employee, and then they have to reasonably justify in case they want to refuse, or they have to agree on granting the request. The new directive also, the new regulation kind of included also other paid and unpaid leaves to take care of family members. Main one, I would say the main difference is there are new permits, paid leaves, also a parental leave for 8 weeks that has been implemented, but it kind of extended to civil partnerships. So actually, there's a permit for marriage. When someone gets married, you get 15 days off, and that's also extended to civil partnerships. And then all the paid leaves or unpaid leaves that were in place for the family members of your partner, then that also extend to civil partnerships. And then finally, the last thing I wanted to flag with this and why it becomes relevant as well is that the exercise of these rights will also provide protection for employees in case of termination. In Spain, the termination needs to be for grounds, so you need to have a valid reason to terminate an employment agreement. If not, the termination will be unfair. Or if the termination is done to a protected employee or in breach of the employee's fundamental rights, it will be null and void. And null and void trigger reinstatement. So the employee has to be reinstated in the position with back pay. And therefore, the exercise of the rights classify the employee as protected, meaning that any termination which is unfair will be considered void, triggering the reinstatement. So again, new rights for employees in the use of it's just the purpose of the rule and the regulation is to enable the employees to actively take these leaves without being subject to retaliation from the company, subject to an unfair dismissal. And that's it from Spain. I'm going to hand it over to my colleague Lawrence to talk about the French updates.
Thank you, Anna. I'm going to start with the EU Pay Transparency Directive. This, of course, is not brand new. It was adopted about a year ago, and member states have to transpose the directive into local law by June 2026, so 2 years from now. So why are we talking about it today? Important to start preparing well in advance to be ready to comply with the new local rules once they're adopted. Of course, that hasn't happened yet. As a reminder, the key provisions in the directive, first of all, at individual employee level, what one might call the end of pay secrecy. So there are provisions in the directive applicable to job candidates. You can no longer ask a candidate what their current or past pay is or was. As regards your existing workers, they will have the right to ask for information about how much their colleagues are paid. So that is specifically within their category, which is a key notion in the directive, the notion of equal work or work of equal value. Is clearly one that's going to be debated a lot in practice within individual companies. So yeah, employees can ask, what is the average pay of my colleagues? And the company has to provide that broken down by gender. Also secrecy related, you'll no longer be able to prohibit employees from telling their colleagues how much they earn. The other key limb of the directive, collective level, it's about gender pay gap reporting. So this is going to apply to all companies with at least 100 employees. That's at the level of legal entity rather than group wide. In time, any company with at least 100 employees will have to report their gender pay gap across the whole company, but also broken down by category of worker. Again, that notion of equal work or work of equal value. So how will that reporting work? For larger companies, at least 250 employees, that will be annual reporting for the calendar year of 2026 onwards. So the first report to be produced in 2027. And for smaller companies, they only have to report once every 3 years, and that will be from either 2027 or for companies below, I think it's 150 headcount, from 2030 only. So more time to prepare for those. In practice now, we think it's important to start working out objective methodology, how you're going to evaluate and classify the jobs that exist within your company so that you can justify how you've divided employees into categories of people doing work of equal value. We think it's worth getting ahead on that in order to try different models, perhaps, see what results you get in terms of pay gap so that you have time to think about, are we doing this the right way? Should we be taking a different approach in our employee categories? And that preparatory work will really be important when you think about, from next year, any employee across the EU can ask their employer, from 2026, can ask their employer for the average pay of their colleagues. That, of course, immediately means the employer needs to be ready to explain any differences that are turned up in replying to a request of that sort. Final limb of the directive is the so-called joint pay assessment. So this is essentially a process that the employer has to go through if once they are subject to the reporting obligations, they identify a pay gap, a gender pay gap of at least 5% in any given employee category. If they can't justify that gap objectively, and if they haven't within 6 months of when the gap was reported remedied it, they have to go into a joint assessment process. It remains to be seen the detail of how member states will set out that process, but the directive says you do it in cooperation with your employee representatives. So in France, one might anticipate that there'll be a requirement to consult your works council, if you have one, perhaps about the methodology of the assessment and indeed on the outcome. So again, what should companies be doing now to prepare? I think it's worth keeping in mind that even today, of course, there are already local legal gender pay gap reporting obligations, for example, in Ireland, the UK, in the US, and indeed in France, where for some years now there's been an obligation to calculate and publish an index if you have at least 50 employees. Now, the French rules, which are really quite detailed in terms of how you run the calculations, they do give you some flexibility or some choice in terms of how you define employee categories. You can make the choice of simply dividing the whole workforce into the 4 so-called socio-professional categories. That may be a preferred approach for some employers. It remains to be seen, however, how France will adjust its existing French rules in order to comply with the directive on that particular point. So that degree of flexibility that exists in France at the moment, in principle, ought to disappear if the directive is actually implemented properly in France. I think more generally, in terms of planning ahead, if your company already has some kind of gender pay gap reporting arrangements, then you need to be doing a gap analysis to look at how you'll need to change them in order to comply across Europe with the new rules in 2 years. If you have no gender pay gap reporting at all in place currently, I think you need to start by looking at the directive's requirements, because we don't have the local law requirements yet, but thinking about, do we have the HR processes in place to capture the data that we will need in order to comply quite soon with these reporting requirements? And I mean, just one example, but I think it's an important point. Which pay are you taking into account when you're comparing how much people earn and whether there is a pay gap? So the definition of the term pay in the directive is very broad, and it includes indirect remuneration. It includes variable, of course. So it's clearly wide enough, for example, to include share options and RSUs granted by your parent company. So important to have methodology set up so that you're capturing the right information and comparing the right pay elements once you have to comply. In practice, assuming you have employees in more than one EU member state, you'll probably also want to think, are we going to try to comply with the local laws in every country where we do business, knowing that they will be, that the directive rules will be transposed differently in different countries? That unfortunately is inevitable. There will be some variations. Or do you adopt a pragmatic one-size-fits-all in the interests of consistency and hope for the best? Important strategic questions to think about over the next 2 years. If we could move to the next slide, please. So brief word on damages for unfair dismissal in France. So before 2017, there was no limit on these damages. In fact, there was a minimum of 6 months total comp for any employee with at least 2 years services. Employers will be glad that that level of minimum award doesn't exist anymore, though there are minima according to length of service. The maximum, known as the barème Macron maximum, is a cap that was introduced in 2017. So that limits the amount of damages that courts can award. The quantum is roughly 1 month per year of service, certainly for the 10 years, then it slows a bit. The absolute maximum is 20 months pay when you get to, I think it's 30 years service. Now, we've had this maximum for nearly 7 years. the validity of this maximum was challenged immediately in the Constitutional Court when the legislation was first adopted, and it was held to be valid. Since then, it has been challenged in the Judicial Supreme Court, the Cour de Cassation. Typically, the arguments raised to say this maximum is illegal, basically, are to say that it's contrary to provisions of the ILO Treaty number 158 and also the European Social Charter, because both of those documents provide the principle that an employee who is unfairly dismissed should be able to obtain adequate damages or some other form of appropriate reparation. Despite the maximum being law in France since 2017, it has until now been quite widespread practice for at least the lower courts, so labor courts and local courts of appeal in France, to decide that a higher award than the amount provided by law as a maximum should be awarded, taking into account the fact of the particular case, which might be, an employee who is in his mid to late 50s with only 2 years service, with 8 children, etc. Anyway, in May of this year, a further decision by the French Judicial Supreme Court was issued, again holding that the cap is indeed valid. So I think we can expect over time that any sort of resistance by lower courts defying the position of the Supreme Court will become, I think, increasingly rare in France. Anna, may I turn back to you briefly?
Yeah.
I think you've mentioned there's something similar in Spain.
Yes, so not as frequent as we've seen in France, but it's funny because, the same provisions of the ILO treaty and the Article 24 of the European Social Charter was used by a high court in Catalonia last year to define. So in Spain, the process is similar to France. The severance or the compensation applicable in case of an unfair dismissal is just set up by the law. It's a number of days of salary per year of services. And that has been applied, and it has been declared by the Supreme Court, actually, that was a valid compensation provided by the law, and that therefore that's the one applicable. But in this case, where this High Court ruled that additional damages need to be granted, and they actually did, it was a situation where actually the length of services of the employee was very short, and therefore the severance applicable was kind of minimal, and also the employee didn't have sufficient period of contributions to the Social Security, which is relevant because in that case the employee didn't qualify to get the unemployment allowance. So that's where the court says, this isn't sufficiently compensated because the severance is too low, that the employer is just, too cheap to terminate, let's say it that way. And also the employee suffers damages because they cannot get access to the allowances that they would get otherwise. So the damages that the employee did suffer for not having the sufficient period of contribution to the Social Security to get the unemployment allowance were considered sufficient to justify an additional severance. Also, that the other factor on this case is that right after this dismissal, the company executed a suspension of employment contracts, like a furlough, where all the employees would go to unemployment. And if this employee would have remained employed, they would have access to that unemployment. So, all in all, I believe it's an exceptional case. We're hoping for it because the rules are very clear in Spain, like, unless there's a breach of fundamental rights or a protected employee where the termination can be void, then it will be unfair, and it's this number of days of salary per year of service. So it's kind of very clear, but if additional damages start being granted, then the rules are kind of unknown. So yeah, it seems that the claims that are being filed in France have crossed the border and are now being claimed in Spain as well.
Thank you. Very similar to Italy. Very similar to Italy, as we saw, there are lots of similarities in these European countries. Most of the employment and labor rules come from the European structure. So France, Spain, and Italy are still under the European Union. So of course we have many similarities. Also the structure of our judicial labor courts very similar. So next slide, please, Sophia, because I think I need exactly to read the CLE code. So for all the attendees here, thank you very much for being with us. The CLE code is SS4587. So again, SS like Seyfarth show 4587. Thank you for being with us. I think we ran out of time, or at least we're finishing exactly in our 45 minutes. We received many questions, so thank you very much. We will come back to you privately. Here you can find all our details, so reach out to us if you have any doubt on what we discussed today. We were glad to have you here with us. Thank you very much for your participation, and see you next time in the next European webinar.